The United States Supreme Court in Amalgamated Food Employees Union Local 590 versus Logan Valley Plaza, Incorporated, evaluated whether shopping mall owners could prohibit peaceful picketing on mall property. Logan Valley Plaza, a suburban shopping mall in Pennsylvania, opened in 1965. The mall included Weis Market, a grocery store that employed non-union labor. Shortly after Weis Market opened, union employees from Weis's competitors began peacefully picketing the store. The picketers congregated outside Weis Market in the parcel pickup area and the adjacent portion of the mall-owned parking lot. In response to Weis and Logan's petition, the state court enjoined picketing on mall property. The injunction relocated the picketers to the berms, which were areas of raised land between the shopping mall parking lot and the public roads outside the mall. On review, the Pennsylvania Supreme Court affirmed the injunction because the picketers were trespassing on private property. The United States Supreme Court granted cert to determine whether a shopping mall owner could employ state trespass laws to prohibit peaceful picketing on mall property. Justice Marshall, writing for the 6-justice majority, concluded that the injunction violated the picketers' First Amendment rights. The First Amendment protects peaceful picketing in areas generally open to the public. Under some circumstances, private property can be considered open to the public. The court cited Marsh v. Alabama, in which the court examined First Amendment rights in the context of a company town. A company town is a community where a commercial employer owns the entire town, including residences, utilities, and retail stores. In a company town, an area that included stores and businesses was the equivalent of a town square, and thus open to expressive activity. Here, the court applied Marsh's rationale to shopping malls. Like the company town, the mall was surrounded by public roads, sidewalks for pedestrian use, and roadways within the parking lot. The general public had unrestricted access to mall property, which makes mall property similar to a town square. Thus, the mall couldn't prohibit picketers from exercising their First Amendment rights on mall property. By relocating the picketers to berms far from the supermarket, the mall owners substantially hindered the picketers' communication of their ideas. Unlike a homeowner, the mall had no claim to privacy rights. Further, the picketers hadn't interfered with normal business operations. The mall's ownership of the premises, without more, couldn't justify its prohibition of the picketers' expressive activities. Had Weis Market been located in a traditional downtown, there'd be no question that the First Amendment protected peaceful protest on adjacent public sidewalks. The court was concerned that suburban shopping malls could create a cocoon of protest-free space simply by building large parking lots around their businesses. The court added that the mall's owners could still create reasonable rules governing the exercise of First Amendment rights on their property, but the court offered no guidance on the limits of the mall's rulemaking authority. Thus, the United States Supreme Court reversed the decision of the Pennsylvania Supreme Court. Justice Douglas concurred that the shopping mall had opened its property to public use and that the picketing was directly related to shopping mall business. Justice Black, who authored the court's Marsh decision, dissented. Unlike the company town, the shopping mall owned no homes, sewage disposal plant, or post office. Marsh concluded that private property could be treated as publicly held for First Amendment purposes only if it possessed all the attributes of a town, and thus enabled private property owners to stand in the shoes of the state. This was not the case for malls. Justice Harlan also dissented, arguing that application of federal labor laws could resolve the case, thus avoiding the constitutional question. However, the picketers hadn't preserved that issue for appeal. Harlan would have dismissed the writ as unwisely granted. In his dissent, Justice White concluded that, unlike public streets available to all for a variety of purposes, the mall invited the public only to do business with the shops located there. In 1976, the court in Hudgens v. National Labor Relations Board recognized that its 1972 Lloyd Corporation v. Tanner decision had effectively overruled Amalgamated Food Employees Union Local 590 v. Logan Valley Plaza, Inc. In denying students a First Amendment right to distribute anti-war pamphlets at a shopping mall, the Lloyd Court largely adopted the reasoning of Justice Black's dissent in Logan. As a result, private property is treated as publicly held for First Amendment purposes only if it has all the attributes of a municipality and enables its owners to stand in the state's shoes.